Margaret Ellis did not look like someone who could change the outcome of a courtroom. She was 58 years old, wore a plain navy cardigan, and carried a binder so thick that the metal rings strained to hold it closed. Her reading glasses hung on a beaded chain around her neck. She had arrived early, found a seat at the defendant's table, and placed her binder in front of her with the quiet care of a person who had done important work for a long time and no longer needed anyone to notice. No one noticed. The lawyer on the other side of the room was a partner at one of the city's most respected firms. His suit was the color of a storm cloud. His briefcase was Italian leather. He had 3 associates with him, and they arranged their laptops and folders with the confident efficiency of people who expected to win before the judge even sat down. He glanced at Margaret once, the way you glance at furniture, and then turned back to his papers. Judge Raymond Hollis entered at 9 o'clock exactly. He was 61, thick through the shoulders, with gray hair that he kept short and a voice that filled a room without effort. He had been on the bench for 19 years. He was not a bad man. He was, however, the kind of man who had been right so often and for so long that he had stopped noticing when he was making an assumption. He looked at the room. He looked at the opposing counsel and gave a small, familiar nod. He looked at Margaret and paused, the briefest pause, almost nothing, and then opened the case file in front of him. The case was called. Margaret stood and announced herself. "I am appearing pro se on behalf of Mrs. Constance Ward," she said. Appearing pro se meant she was representing her client without a lawyer beside her. She herself was not a licensed practicing attorney. She was, as the court would see it, a civilian with a binder. Judge Hollis leaned back slightly. He looked at her with an expression that was not unkind but was, unmistakably, patient in the way that a teacher is patient with a child who has walked into the wrong classroom. "Ma'am, are you certain you don't want to request a continuance so you can retain counsel? These are complex legal matters. I want to make sure you understand what you're walking into." Margaret looked at him pleasantly. "I appreciate the concern, Your Honor. I am prepared to proceed." He nodded. He did not look convinced. He looked, if anything, more patient. To understand what happened next, you have to understand what brought Margaret to that courtroom in the first place. Constance Ward was 79 years old. She had lived in the same house on Alderman Street for 43 years. She had raised 3 children there, buried a husband there, and planted a garden in the side yard that the whole neighborhood had quietly admired for decades. The house was not grand. It was a small, pale yellow structure with a porch swing and a mailbox shaped like a rooster. It was, to Constance, the whole world. 18 months before the hearing, a notice had arrived in Constance's mailbox. It was official-looking, covered in legal language, and signed by a company called Meridian Property Solutions LLC. The letter informed Constance that she owed back property taxes from several years prior and that, because those taxes had not been paid, the lien on her property had been sold. If she did not pay the full amount, including fees, penalties, and interest, within 30 days, the transfer of her property would proceed. Constance had paid those taxes. She had the receipts. But the receipts were old, and the letter was frightening, and the 30-day clock had already started. She brought the letter to Margaret. Margaret had been Constance's neighbor for 11 years. She had retired from teaching constitutional law at the State University 4 years earlier. When Constance sat down at her kitchen table and slid the letter across to her, Margaret read it once, quickly, and then read it again slowly. She recognized what she was reading. Not just a legal document. A pattern. She had written about this exact pattern in a law review article in 2009. A company would quietly purchase tax liens, often on small administrative errors or disputed amounts, and then serve notice in a way that was technically legal but carefully designed to confuse the homeowner. The notice would be missing specific language required by state statute. That missing language meant the homeowner's right to a proper hearing had been quietly removed. Most people never caught it. Most people paid, or panicked, or lost their homes without ever understanding why. Margaret had seen it before in the cases her students brought her. She had seen it in case law from 3 other states. And now she was looking at it on her neighbor's kitchen table. She could have called a colleague. She knew practicing attorneys. She knew judges. She could have made 2 phone calls and had someone with a firm name and a business card standing at the table within a week. She chose not to. She chose not to because she had been thinking about something for a long time, about the way courts sometimes treated people who arrived without credentials on display. About what happened when a judge looked at someone and had already decided, before a single word was spoken, what kind of person they were. She wanted to see it happen. More than that, she wanted the record to reflect it, clearly and completely, so that no one could argue it away later. So she appeared alone, with her binder, in her navy cardigan. And she waited. The hearing began. Margaret's motion was a motion to vacate the tax lien transfer. In simple terms, she was asking the court to cancel the transfer of Constance's property, on the grounds that the process used to carry it out had violated her constitutional rights. Judge Hollis let her begin. She had been speaking for perhaps 3 minutes when he interrupted her for the first time. Just to make sure we're all on the same page, a motion to vacate means you're asking this court to undo the transfer. Is that your understanding? Yes, Your Honor. That is my understanding. She continued. He interrupted again 2 minutes later, this time to explain what the burden of proof was in civil motions. He explained it carefully, in simple terms, as though she might not have encountered the phrase before. "Thank you, Your Honor," Margaret said. "I am familiar with the standard. I will be addressing it directly." She continued again. The third time he spoke over her, he suggested she might want to organize her argument more clearly before proceeding. He said it gently. He said it with the confidence of a man who believed he was helping. Margaret set her glasses down on the table. She looked at the judge. "Your Honor," she said quietly, "I will be as clear as I possibly can." And then she began, in earnest, to take the case apart. She started with the notice. She placed a single page on the projector, a side-by-side comparison. On the left was the exact language required by the state tax code when a property lien is transferred and the homeowner must be notified. On the right was the actual notice that Constance Ward had received in her mailbox. 4 words were missing from the right side. 4 words that the statute required. She did not shout this. She did not emphasize it dramatically. She simply showed it and explained, in clear and straightforward language, what those 4 words meant legally. They were not decorative. They were not administrative filler. They were the specific language that gave a homeowner notice of her right to a formal hearing before a transfer could proceed. Without those words, the notice was not legally sufficient. Without a legally sufficient notice, the transfer itself had no valid foundation. The judge said nothing. He was reading the comparison. Margaret moved to the case law. She cited a 1950 Supreme Court decision that established the constitutional requirement for adequate notice before a person's property could be taken. She explained what adequate meant in that context, and then she showed how the notice Constance received fell short of that standard. She cited a 1976 Supreme Court case that laid out the test courts use when deciding whether a person's procedural rights have been met. She walked through the test, point by point, applying it to the facts in front of them. Then she cited a 2017 federal appeals court decision from another state that had struck down a nearly identical scheme, same company structure, same missing notice language, same pattern, on exactly the ground she was raising now. The opposing counsel objected. He argued that the 2017 case was from a different jurisdiction and carried no binding authority in this state. Margaret nodded. The case is not binding, she agreed. However, the constitutional standard it applies is binding, as it derives from Supreme Court precedent. Additionally, she turned a page in her binder. This state's own appellate division issued a decision in 2021 addressing a similar notice deficiency. The court held, in that case, that the failure to include required statutory language in a lien transfer notice rendered the transfer void under state law. I have a copy for the court if it would be helpful. She placed a clean copy of the case on the bench in front of the judge. He picked it up. He read it. He read it for a long time. In the gallery, the lawyers who were waiting for later hearings had stopped shuffling papers. The court reporter's fingers moved steadily, capturing everything. One of the opposing counsel's associates leaned slightly toward another and said something quiet. The other associate did not respond. The second objection came when Margaret moved to the question of the company's structure. She argued that Meridian Property Solutions had been incorporated specifically to carry out these transfers, and that its principals had used a nearly identical approach in at least 7 other properties in the county over the preceding 3 years. She introduced copies of those 7 notices. Each one had the same missing language. The opposing counsel objected to the relevance. Margaret addressed the objection by citing the rule of civil procedure that allowed pattern evidence to establish intent and practice. She cited the rule number from memory. The judge looked at her. It was a different kind of looking than before. 40 minutes had passed. The courtroom had taken on a different quality. It was not loud. It was not dramatic. But something had changed in the way the air sat in the room. Judge Hollis had stopped leaning back. He was sitting forward now, his elbows on the bench, the 2021 appellate decision and Margaret's comparison document open in front of him. He asked her to clarify one point in the 2017 case, specifically, whether the court in that case had addressed notice requirements under state law or federal constitutional grounds. Both, she said. The court found the notice deficient under both the federal due process standard and the state's own statutory requirements, and it held that the 2 grounds were independent, meaning either one alone would have been sufficient to vacate the transfer. And your argument here rests on both grounds as well? Yes, Your Honor. Either ground is sufficient. Together, they are, I would submit, conclusive. He looked at her for a moment. Not with patience, and not with the measuring glance from the beginning of the hearing. He looked at her with the expression of a man who is doing a quiet, internal calculation, and whose answer is not coming out the way he expected. I am going to take a brief recess, he said. 30 minutes. I want to review the materials more carefully. He stood. Everyone stood. He left the room. Margaret sat back down. She took a drink of water. She straightened the pages in her binder. Across the room, the opposing counsel was speaking quietly with his associates. His voice was low. His expression had changed. Judge Hollis returned in 28 minutes. He sat. He looked at his notes. He looked at the room. And then he spoke. He said that he had reviewed the motion, the comparison document, the case law cited, and the 7 additional notices introduced into evidence. He said that the statutory language required under the state tax code was clear, and that its purpose, to ensure homeowners understood their right to a formal hearing, was well established. He said that the omission of that language from the notice served to Constance Ward was not a minor error. It was a substantive deficiency that had the practical effect of removing her right to respond before the transfer occurred. He said the transfer was void. The court finds that the notice provided to the respondent failed to meet the constitutional minimum required under established due process standards. The transfer is accordingly vacated as void ab initio. Void ab initio is a Latin phrase that means void from the very beginning, as though the transfer had never happened at all. Constance Ward's home had never legally left her hands. The ruling was entered into the record. The hearing was closed. The opposing counsel gathered his things. His face was professional and controlled, but he did not look at Margaret as he passed her table. His 3 associates followed him out. Margaret stayed where she was until the room was nearly empty. Then she turned toward the gallery, where Constance Ward had been sitting in the second row for the past hour. Constance was standing now. Her hands were folded in front of her. Her eyes were full. Margaret walked over to her and put a hand on her shoulder. "You're going home," she said. Constance nodded. She could not speak. She pressed Margaret's hand with both of hers, and that was enough. 2 days later, Judge Hollis issued his written ruling. It was 8 pages long. It cited 6 of the 7 cases Margaret had raised. It traced the legal argument with careful precision, moving from the constitutional standard to the state statute to the specific facts of Constance's notice. In several places, the language of the ruling tracked so closely to the argument Margaret had made from the table that it was clear the judge had understood everything she said. The ruling was thorough. It was unambiguous. It was, in its way, an acknowledgement, not spoken aloud, not delivered as an apology, but present in every paragraph of a document that said, clearly and for the permanent record, that she had been right. The story did not end there. A legal advocacy journalist wrote a piece about the case 3 months later. The article noted that Margaret had quietly assisted in overturning 11 similar lien transfer cases in 3 counties over the preceding decade. She had never charged a fee. She had never sought credit. She had often worked as an unseen advisor, helping younger lawyers build arguments that they then presented themselves. In a handful of cases, when she believed something specific needed to happen in the courtroom, she had appeared herself. When the journalist asked her why she had chosen to appear alone in this case, without the name of a law firm behind her, without a colleague at her side, she thought for a moment before answering. Because I needed the judge to show me who he was before he understood who I was. Once they underestimate you, the law does the rest. The journalist also reported that the State Attorney General's office had opened a review of Meridian Property Solutions LLC following the ruling. 14 months after the hearing, the state legislature passed an amendment to the property tax code. The loophole that had made the scheme possible was closed. The company dissolved shortly after. Constance Ward sent Margaret a tin of shortbread every Christmas after that. She made it herself, buttery, simple, the kind of thing you eat slowly because it tastes like something good that you almost lost. She passed away 2 years later, at 81 years old, in the house on Alderman Street where she had lived for 43 years. The porch swing was still there. The garden was still there. The Rooster mailbox stood at the end of the front walk, a little faded from the years, but standing. Margaret attended the small service that Constance's family held in the house. She sat near the back. When Constance's daughter found her afterward and said, simply, "She talked about you all the time," Margaret smiled and said she was glad. She did not say much else. She did not need to. Some things do not need to be spoken to be completely understood. A home returned. A record set straight. A tin of shortbread arriving at the door every December, year after year, until it did not arrive anymore, and even then, the fact of it remained. The law, when it is used carefully and without fear, is a remarkable instrument. It does not care how old you are, or how quietly you dress, or whether you arrive with a leather briefcase or a worn binder with the rings straining to close. It does not care whether the person on the other side of the room has 3 associates or 30. It asks only one question, and that question is the same every time: what does the evidence show? On that morning in courtroom 4B, the evidence showed everything. And Margaret Ellis, in her navy cardigan and beaded glasses chain, had known from the moment she walked through the door exactly what it would show. She had simply waited for the room to catch up. End of story.